Is my microphone working? Can you hear me? Okay.
Yeah. Okay. It's 10 o'clock. Good morning. Welcome to an oral argument session of the 5th District Court of Appeal by Zoom today. It is Tuesday, October 8, 2024. This panel has one case this morning. The panel consists of me. I'm Judge Lambert. I'll preside. With me on the Zoom, as you can see in the boxes there, are Judges Eric Eisnagel and Judge Jordan Pratt. Our case today is case number 5D23-1263. Christopher Moncrief as the personal representative of the estate of Melissa Marie Moncrief, deceased, versus Charles Edward Colmer, MD, and New Smyrna Orthopedics, PA. You'll see in the upper, at least on my screen, the upper left-hand corner, there is a clock. Each side will have 20 minutes for their oral argument. Typically, we reserve 5 minutes for the appellant. Once you get into your 5 minutes, the yellow light will start flashing, and you can obviously continue on as long as you want. Otherwise, other than you don't get 20 minutes in the aggregate. So if you use all your time in your initial argument, absent the kindness of me, you'll not have any additional time. We are being live streamed, so I'm sure our audience has moved away from the Weather Channel to watch us this morning. And so we just keep that in mind as you're talking with us. Also, if you have any electronic devices, please either turn those off or in the mute position so they don't interfere with either you or your opposing counsel or the court. That said, Mr. Carlisle, if you're ready to proceed, you may go ahead, sir.
I am. Thank you very much, Your Honor. May it please the court, my name is Chris Carlisle, and as you mentioned, Judge Lambert, I represent Melissa Moncrief as personal representative, Christopher Moncrief as personal representative of Melissa Moncrief's estate. Your Honors, we're here today on a fairly straightforward case that involves really the consideration of 4, maybe 5 things. The affidavit that Dr. Schur filed, the deposition testimony of Dr. Schur, and then the statutes that we're dealing with and how it relates to those statutes. It's de novo review of this court, obviously, looking at those materials and construing the statutory language to see if Dr. Schur was qualified as an expert pursuant to those statutes to give a pre-suit opinion. We know the statute dealing with pre-suit references a written medical opinion from an expert as defined in 766.2026. That statute states a medical expert means a person duly and regularly engaged in his or her profession. And then obviously having a healthcare degree, which is not at issue, and then references 766.102. So the first question for this court is whether or not Dr. Schur was a person duly and regularly engaged in his or her profession.
Counsel, was the evidence undisputed that Dr. Schur, the only time, it seems like, the only time he saw patients, or I know he testified, I see patients, I make a diagnosis, write a report, etc. But was the evidence undisputed that that only occurred in his capacity as an expert for litigation purposes?
I don't know that it's undisputed, Your Honor. There is testimony where, again, yes, it seems to be his testimony was the vast majority of his practice was doing CMEs and IMEs. There were questions that were posed to him about, did you ever offer any additional opinions? At times he said, that's not really my place, but if I was asked, I would do that. He was asked if he ever was in an operating room, and I believe he answered that he had done that in the last few years.
I mean, I think it is. Counsel, I guess the key for me, though, is, I understand he's doing a lot of things that a doctor in the specialty would do. I guess what I'm asking is, in what capacity was he doing those things? Was there ever any evidence whatsoever that he did those things in a clinical capacity? And in other words, and the way I say that, maybe we can argue about what clinical means, which the brief doesn't really argue that. But was he ever doing it as a healthcare provider as opposed to a expert for litigation? Right. So your brief seems to suggest that that I think it's the Morris case is
Yes.
binding on us and decides our case here. I'm not so sure that's right. The evidence
Well,
well, hold on, let me finish. The evidence in Morris seems to be notably different than the evidence here. Very clearly, the evidence in Morris was the expert in that case was rendering medical care in the capacity of a physician at several different hospitals. Can you point me to the record, any evidence whatsoever, that Dr. Schur was doing that as opposed to simply acting as an expert?
Your Honor, I suggested to the court, in answer to your question first, that Morris and the principles there are still good law. And one of the reasons I cited supplemental authority about a week ago, a case from the 6th, which was the Fredaxi, if I'm pronouncing that correctly, case, where the 6th DCA, and even in May of this year, recognized that Morris requires the statutes be construed in a manner that favors access to the courts. That case also went through and talks about the primacy of text
Counsel,
principles
you
for
have a case-
statutory
just so
interpretation.
we don't get sidetracked, I want to get my question
Yeah.
answered first, and then we can move on to those things, and we can talk about what it means to liberally construe, et cetera, et cetera. That just seems like a different issue. My question is there any evidence whatsoever, anywhere in the record, that says, hey, Dr. Schur was practicing within the relevant time period as a medical doctor for the care of patients, as opposed to a legal expert in litigation?
Was he?
There is
treating
evidence in his testimony. He was asked, this is at page 292, 293. There was a lot of testimony during his deposition. Will you tell us whether you have actively and continuously engaged in the practice of orthopedic surgery up until May 2021? Yes, and I continue to this day. We can again parse over what exactly that means. I don't think there's any dispute that the vast majority of what he does is consulting as an expert.
If we read his testimony, it seems clear that he thinks that is the practice of his specialty, that being an expert witness is the practice of his specialty, assuming for the moment that the court disagrees. Other than sort of very, very high level conclusory statements like the one you just read, is there any evidence that actually establishes in any way, again, not in a conclusory fashion, that Dr. Schur was practicing medicine, seeing patients for the purposes of healthcare as opposed to as a legal expert in litigation?
He made pretty clear that he had given up the active practice of medicine in the sense of not doing orthopedic surgery, et cetera, and has been doing this exclusively, the medical consulting, medical/legal consulting for a period of time. So I think, again, obviously the court can read the deposition. There are some of those statements where, again, as you mentioned, clearly he believes that he's engaged in the practice of medicine. But the question becomes, what are we looking at as far as meeting the statute? And I think, Judge, you mentioned some terms about clinical practice, et cetera, et cetera. But for the purposes of this provision, we're talking about a person duly and regularly engaged in his or her profession. It's not a regularly and duly engaged in practicing orthopedic surgery. It's in this profession. And our position is that looking at his deposition testimony and his experience and his 35 years of practice and the fact that he is still licensed a medical doctor, that type of practice that he is engaging in meets the statutory definition.
So,
A
Mr.
person
Carlisle,
duly and regularly engaged.
I'd like to ask you just a hypothetical, just to see if we can tease out, the way that you're looking at the statute versus how your friend on the other side is looking at it. Let's suppose that Dr. Schur, immediately after graduating medical school, maybe he had some fantastically placed article and was recognized as a subject matter expert in this field by virtue of that article. Let's just say that he went straight into legal consulting, didn't practice for 35 years, but was continuously engaged in this sort of legal consulting work straight out of medical school. Would you be before us telling us that he qualifies to render an opinion under the relevant statutes, or do you think that that changes it sufficiently such that he wouldn't be qualified?
So he would be a medical doctor, but he never practiced, and then he went into legal consulting immediately after law school.
Sure.
Is that the hypothetical? Your Honor, again, I think if the statute is what we have to look at here, a person duly and regularly engaged in his or her profession, I don't see written into that statute a requirement of a certain number of years to have a quote unquote clinical practice, which is not part of this provision. I don't see a requirement that it could be there. I think, again, if we're going back to the concept, and I know that there are judges in this state, including on this court, that disagree with interpreting these statutes under Morris's dictate that they be done with providing access to the courts. But I think under your hypothetical, if we look at the wording of the statute, duly and regularly engaged in the practice of his or her profession, that arguably your hypothetical would meet that. And again, if we are trying to do this, and the purpose of all this is not to put up barriers or create technical bars from going forward, it's to provide the other side with a legitimate opinion about whether or not malpractice occurred. That clearly was the case here. He clearly practiced medicine for 35 years in various capacities. And I think under the term regularly engaged in his or her profession, he does meet that statutory definition.
Counsel,
Now,
And to go-
when you look at the word profession, do you define that as the practice of medicine generally? Or do you think that profession means the specific subset of the practice of medicine in which Dr. Shore specialized?
I think that all I can look at is the wording of the statute, which says profession, not subspecialty, not active clinical practice. It says his or her profession, which is defined and written broadly, and we have to assume that was done for a reason. There's
Counsel,
no doubt he is.
Is the profession a legal expert in court or a medical doctor rendering treatment to patients in a medical facility? Or are those the same thing?
He's doing examinations, and he's testified in his deposition that he's done hundreds of these that can be hundreds of pages of long, that require a medical degree to do, that require his skill that's been acquired over 35 years to do. And so again, we're all kind of searching for these definitions that the legislature chose not to put into the statute. And if we're going back to engage in his or her profession, I don't know, based on what he testified to, how that can be anything but being engaged in his or her profession. It's not, again, being a cutting, as we would say, orthopedic surgeon and doing those type of surgeries, but he certainly is examining patients and practicing medicine in that sense.
How is doing and look, I get it, right? And I think we started out by saying, hey, he was doing a lot of things that a medical doctor might do, right? Or at least according to the undisputed testimony. I guess the question that I'm trying to get at is when you evaluate a patient, or when you evaluate an injured person of whatever, and you're doing it for the purposes of legal work, litigation, to provide expert testimony in a case, how is that the active clinical practice?
Well, I think, again, it doesn't say active clinical practice. It says his or her profession. And I think if we're looking at,
hold on. There's no statutory language that says active clinical practice.
The active clinical practice you're talking about is under 766-102-5A2A, right, which I'd love to talk about.
Well, let's talk about
so again, well, thank you. I'm running out of time. I'm trying to hit both of the statutes we're dealing with. So we have the one that we've been discussing, which broadly defines engaged or his or her profession. Now we have this more specific statute that talks about devoting professional time in the 3 years prior to the occurrence to, and the key language is the active clinical practice of, and the important word here is or consulting with respect to the same specialty. I think there was some argument in the answer brief that somehow the wording actual clinical practice of controls over the next phrase, which is or consulting with respect to. And I think, again, giving the word consulting its plain meaning, which under the supremacy of text principle, you have to do. We gave some examples of what consulting means. I don't think there's any doubt that he testified that he's been doing that for a long time and he would meet that definition. So we can't.
Well, no, but does it have to be consult? No, there's no doubt he's consulting. No doubt.
Okay.
Right? Clearly, hands down. But in what capacity is he consulting? Is he consulting with a lawyer as a legal expert in litigation? Or is he consulting in a active clinical practice with other medical doctors for the purposes of rendering treatment?
I
Which one
think he
is
is not, his testimony is that he is not doing this in an active clinical practice. But again, I would suggest that the reading of that statute makes it clear that those are two separate things. And I think consulting, as you just acknowledged, he clearly is doing is enough. The statute doesn't say consulting with respect to an active clinical practice. It says the same specialty. We also pointed
But the
out
same
in the
specialty
reply
is
brief.
connected to the active clinical practice, is it not? I mean, if we read the statutory language, including the grammar, isn't the specialty connected to the active clinical practice? And if not, why?
I apologize, John.
No, I mean, just why is that? Why are those two things not connected? Specialty,
Because the word,
active
because number one, because of the use of the word "or" there, which clearly is used for a reason.
well, hold on.
And
It's
again,
no,
it
no, no, no,
says
no.
"or
Hold on, no,
consulting."
It says comma
Yes.
or, and then
Right.
another comma, right? So grammatically speaking, why isn't specialty connected to active clinical practice as a matter of grammar?
I think as a matter of grammar, the actual clinical practice of or consulting with respect to, there is consulting with respect to the same specialty. You have those two things in the statute, all related to the third phrase, which is the same specialty.
Could
You
we
can be
take that
involved in
phrase
the
out?
actual.
What if we took the commas out? Active clinical practice relating to the specialty, right?
I think again, Your Honor, the way it seems clear to me, and again, I respect your disagreement on that, or consulting with respect to the same specialty does not impose the active clinical practice language onto that part of it. And I just like to point out, because I'm running out of time here, because I'd like to save some for rebuttal. We addressed in our answer brief this very section of the statute and how in 2013 the statute was changed. It used to have additional language in there, the same language we're talking about. And it used to say that includes the evaluation, diagnosis, or treatment of the medical condition that is the subject of the claim and have prior experience treating similar patients. That language was removed 11 years ago for a reason. The much more specific type of requirement that was present then is not present there now. And I think, again, the only fair reading of this statute, given that they've removed that language, that he clearly was, as you acknowledge, consulting with respect to the same specialty, which is orthopedic medicine and orthopedic surgery. And I will save the rest of my time if the court wishes.
That's fine.
Thank you very much.
Thank you, counsel. All right, is it Van Cole?
Yes, Your Honor.
Okay. All right, sir, you have 20 minutes if you're ready.
All right, appreciate it. Wilbert Van Cole on behalf of the appellees, Dr. Comer and New Smyrna Orthopedics. May it please the court.
Mr. Van Cole, could you begin by addressing your friend on the other side's argument that the profession that we're talking about is simply the practice of medicine, and that in the course of rendering opinions to a reasonable degree of medical certainty in the context of legal consulting, that constitutes the practice of medicine, such that Dr. Shore has been continuously engaged in the practice of his profession? Could you give us your perspective on what the profession means? Does it simply mean the practice of medicine as a general matter, or does it mean, the clinical treatment of patients within the context of orthopedic surgery or otherwise? If you could address that, I'd be interested in your take.
Sure, Your Honor. I think the only real way to view it is it has to be within the context of clinical practice. And I think the court sort of alluded to the presence of the two commas when we're talking about active clinical practice and consulting. There's a reason it is tied to the phrase active clinical practice of, comma, or consulting with respect to. The two commas serve as a.
I think we're mixing up the two statutes. So my question relates to 202, not 102.
Okay.
Right. So in 202, it talks about, and here, let me get it out. It talks about
Duly and regularly engaged.
duly and regularly engaged in the practice of his or her profession. What is the profession? I see in your brief that at various times you described his profession as orthopedic surgery, and at other times you've described the profession as the practice of medicine.
Mhm.
Right? Those are two different things. Orthopedic surgery is a subset of the practice of medicine. Could you just start by telling us what is the profession that we are looking at?
The profession is the practice of medicine. The specialty is orthopedic surgery. 766.
So has Dr. Shore been duly and regularly engaged in the practice of medicine by virtue of the fact that he has been rendering essentially medical opinions? Of course, this is in the context of legal work, but medical opinions nonetheless. In his framing, he calls them diagnoses. Does that constitute regular engagement in the practice of medicine?
Absolutely not, Your Honor.
And why not?
Physicians, MDs such as Dr. Shore, are controlled by Chapter 458. And Chapter 458 actually defines what the practice of medicine is. Within that statutory provision, subsection 3, it says the practice of medicine means the diagnosis, treatment, operation, or prescription for any human disease, pain, injury, deformity, or other physical or mental condition.
Okay, so the key word is diagnosis, right? Your friend on the other side, I believe, used that term in his, his argument just now. I understand you don't frame what Dr. Shore is doing as diagnosis. Can you help us walk through that? Why is it not diagnosing?
Yes, because if you're a physician and you make a diagnosis that requires intervention, you've got an obligation based upon the physician-patient relationship to make recommendations to treat that diagnosis. Dr. Shore divorces himself of that obligation by saying he's a legal consultant. Even if he sees something, if he makes a diagnosis that requires intervention, his communication is not to the patient. He acknowledges that in his deposition. He says his communication is to the attorney, and then the attorney decides how to communicate that information to the patient. And I think when we use terms like patient, it's important because if, for example, the person Dr. Shore sees is his patient and something goes wrong, Dr. Shore has exposure for that, but it's not his patient.
So just to make sure that I'm tracking here, would it be correct to say that in your view, diagnosis requires a physician-patient relationship, and Dr. Shore, by unrebutted evidence, has no such relationship with any of the folks about whom he's rendering medical opinions?
Yes, Your Honor.
Understanding. Okay.
Absolutely, fully agree with that. That is the crux of our argument. And as the court has honed in on, there is functionally two statutory provisions at play here. I think we started to address 766-202. And the key part is not just, and I think there was some focus on, and I'll be clear, the practice of his or her profession, but 766-202 also requires that the person be duly and regularly engaged in that practice. There is no indication that Dr. Shore, in the time frame that matters, which is May of 2016 to May of 2019, was regularly and duly engaged in the practice of medicine. And the way that the statutory provision works is that both provisions have to be satisfied by a prospective expert in order for them to provide a corroborating affidavit. If either of the statutory provisions are not satisfied by the prospective expert, Chapter 766 requires that that expert be disqualified and that affidavit not be considered for the purposes of the notice of intent, which is exactly what happened in this particular case. So
we could get into 102.
Yes.
Your friend on the other side says, well, consulting, the statute doesn't say consulting for the purpose of rendering treatment. It simply says consulting. Your friend on the other side further, says that Dr. Shore is, offering consulting services. And it's with respect to the same specialty. Can you unpack your argument for us on to the contrary?
Sure, Your Honor. And I think it probably is worth taking a step back. Functionally, the argument that's being raised by the appellant is the statutory scheme permits an expert to provide expert opinions because that expert is an expert. There is no connection with actually practicing medicine. Solely continuing to provide expert opinions means that you're qualified to give those opinions. That's not the way the scheme is set up. And I think sort of the statutory construction that we're focusing on is the supremacy of the text. But part and parcel of the supremacy of the text is not to look at words in isolation, but within the context of that statutory scheme. And although these provisions are not at issue because Dr. Shore clearly acknowledges he's not involved, if we look at subpart B and subpart C of section 5, I think it's illustrative in terms of the issues we're dealing with. For example, a person can be qualified in the same specialty via instruction. For example, a professor, just this provision, the instruction of students, but it's not instructions of all students. It's limited to accredited healthcare professional schools, accredited residency program, and accredited clinical research programs. The other way a person can qualify as the same specialist is through clinical research program. But again, that's limited to an accredited healthcare professional school, accredited residency, or clinical research. So if we look at the statutory scheme, it relates to the teaching, but not teaching of all, but the teaching of medical professionals. It relates to the research, but not the research of everything. It relates to medical research. It'd be inconsistent with subsection B and subsection C, where the scope is limited, to say that you can qualify either if you're active clinical practice or simply giving expert
So,
opinion.
Mr. Van Cole, if we could back up for just a second. I asked your friend a hypothetical. I guess I'll ask you one. You mentioned professors. Let's say, and I understand some of these may be unlikely hypotheticals, but I think it just helps highlight the difference in approach that y'all have to the statute. Let's say that an individual graduates from medical school, never provides healthcare to a patient, but then immediately becomes a professor. Again, has a fantastic article, placed in the Harvard Journal of Medicine, becomes a recognized expert in the field, immediately goes to tenure track faculty, receives tenure, and teaches for 30 years. But the individual has never once treated a patient in the context of a physician-patient relationship. I understand on 102, right? It satisfies 102, right? Because you've got someone who's, instructing students, right, under 102. But let's go to 202.
Mhm.
Has that professor been duly and actively engaged in the practice of his or her profession, the practice of medicine, right? Again, never having treated a patient. What say you? Does that professor satisfy 202? We understand 102. They're good on 102, but what about 202?
That becomes difficult because just in the context of teaching students, it's not normally classroom teaching alone, it's clinical teaching as well. So
I'm asking you to buy into the hypothetical. I understand maybe it's not a likely scenario, but it's at least possible. And I want to hear from you on the terms of my hypo, what you think about it.
Okay, so I guess we live in a world where these clinical professors who are normally required to be clinicians no longer required to be clinicians. I think that's a hypothetical the court has created under that scenario. Is that correct? Am I understanding that correct? I think it would be factually dependent. It would be factually dependent. If that professor is making recommendations to other clinicians and telling the clinicians, this is my suggestion, then yes, I think they would be qualified. If that professor has never, ever engaged in the practice of medicine, I think that becomes a factual scenario that's hard to answer in the abstract. I think that's sort of the rub with that scenario. And it's odd, and I think part of the reason the statute's written this way is that there is a presumption that these professors are clinicians within.
Sure. So what I understand is that you're adhering essentially to your position that the statutory scheme can be satisfied only if, among other things, the expert has a regular physician-patient relationship, right? That seems to be the key for you. Does that sound like an accurate description?
It really is. That is the key, and that's, I think, the way that the statute's created. And I think
would a researcher have a physician-patient relationship?
It depends in terms of the documentation that's signed, whether it's human research. Again, that becomes more of a factual scenario.
It seems even less likely when we're dealing with the researcher, right?
Yes, it probably seems less likely. And I think the key part is the way that the statutory scheme is constructed. There are two parts to it. And I think the researcher, for example, you can be a clinician, but satisfy the subspecialty of being a orthopedic surgeon via research or teaching. But you still have to have active clinical practice. You still have to be involved within that. And I think that's the way the statutory scheme is set up. And I think the legislature did that to ensure, again, that these claims are viable through the pre-suit process before a complaint is filed. So I guess that gets us back to what I was talking about, Your Honors. It relates to subsection A, which is the active clinical practice or consulting with respect to. And I think the hypotheticals that the court has generated are illuminating hypotheticals, and I think it would require sort of the factual world to be changed a bit in terms of how it's set up. What we do know in this particular case is that we do live in a world where there is a cottage industry of individuals serving as expert witnesses, both sides, plaintiff and defendants, in these medical malpractice cases. And that sort of action, that sort of responsibility is insufficient to satisfy 766.102 subsection 5A1. And the reason is because the consulting with respect to is tethered to the active clinical practice. And there is one, and again, it's not this particular DCA, but there is one DCA opinion that alludes to this being insufficient. And we cited to it in our brief, Your Honor, and it's the third DCA case of Winson versus Norman. And in that particular case, it's not a long opinion, but the holding by the court is, and I'll read it verbatim, the doctor in question had not been engaged in the actual practice for more than a decade prior and had apparently confined his recent professional activities to acting as a litigation expert on behalf of the plaintiffs, as in this case as well. And the court said that was insufficient to satisfy the requirements of Chapter 766, and that affidavit and that expert should be stricken. And that's the rub, Your Honor. 766.102 creates limitations on who can serve as expert witness. And the thought process by the legislature is clear based upon the wording. We want individuals who are qualified, separate and apart from expert legal work. And then once they're qualified, then they can serve as expert witnesses.
Counsel, what is under 102? I think it says it refers to a healthcare provider that expert testimony cannot be rendered unless the person is a healthcare provider who holds an active and valid license, yada yada. How does that? Am I reading that correctly, or am I looking in the wrong spot? And if I'm reading it correctly, how does that play into our analysis here?
I think it plays into the analysis of what I was referring to, Your Honor, in terms of Judge Pratt's question, which is in this context, most of these folks are healthcare providers, but even within.
Well, but I mean, I guess my thought is I'm trying to figure out. Obviously, Dr. Schur I think he would say he's a healthcare provider. If he doesn't say that, then you win, correct?
Yes, Your Honor.
Okay. Now let's assume for a moment he says he's a healthcare provider because through the lawyers he's doing evaluations and diagnosis and once in a while even making a recommendation through the lawyer. Is that being a healthcare provider?
No, Your Honor.
And to tack on to Judge Eisnagel's question, you'll note that there is a definition of healthcare provider within 202, right? That's sub 4, which defines healthcare provider as anyone who's licensed under basically the medical chapter. But that definition is only applicable to sections 201 through 212, right? It's not applicable on its face to 102. Is there a statutory definition to which we should look for defining a healthcare provider in 102? Because I understand it's now your position that it means something different than it does in the 202 to 212 context. And where would we look for that definition? Of course, colloquially, we can speak in terms of whether someone's providing healthcare or not. It seems like in at least the colloquial sense, Dr. Schur is not providing healthcare to anyone. But yeah, if you could help us with how to sort through that, I'd appreciate it.
Sure. So section 202 as it relates to healthcare providers, and I think sort of the difference in this particular case, it's relating to the defendants in the case, and that's why it uses the term healthcare provider within that context. But the presumption is, as a healthcare provider and as a defendant, you have provided care to a patient, and that's why the medical malpractice lawsuit has begun. And that's where the healthcare provider term comes from and why it's limited 201 to 212.
Okay, but where do we look for that? Because again, 201, 202 defines healthcare provider as anyone who's licensed, basically, under chapter 458, 459, 468, yada, 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 right? Full stop, anyone who's licensed. I mean, Dr. Schur is definitely licensed. So at least under the 202 definition, he qualifies as a healthcare provider. But that definition only applies on its face to sections 201 through 212. So, is it your position that the term is essentially undefined for purposes of 102? and where would you have us look to, for a definition? I mean, the dictionary, something else, where should we go?
And let me
So-
jump in there as well, as part of your answer. The health definition of healthcare provider under 202(4), right? Unless it's been amended, unless I'm looking at the wrong version, means any hospital or ambulatory surgical center as defined and licensed under Chapter 395. And then it lists what appears to be a bunch of different types of medical facilities. Am I looking at I just want to make sure I'm following the argument. Am I looking at the wrong definition?
You're not looking at the wrong definition, but those semicolons refer to different healthcare providers. So for
Right.
example, hospitals are licensed under 395. As I alluded to, physicians, MDs are licensed under 458. DOs are licensed under 459. That's why the semicolons are used in that particular case,
Gotcha.
as opposed to colons and then listing out the chapters.
Thank you.
So I do think actually 766-202 healthcare provider is useful. The reason is 766-202 applies to defendants. And the only time you're a defendant in a medical malpractice action is if you've established a physician-patient relationship and you've provided care to that patient, and there's some dispute about that care. So 766-202 sub 4 presupposes there is care being provided. Otherwise, you can never be a defendant in a particular case. That's why it's illuminating, because if you then apply that to 766-102, when it uses the undefined term as healthcare provider, I agree. It needs to be licensed, but it also has to have that presupposition, which is there is the provision of care by the expert.
So just to restate, healthcare provider has a common meaning, right? Which means someone who provides healthcare actively to a patient. 202 sub 4, when it lists, among other things, quote, any person licensed under various chapters, it's narrowing the common meaning because it's specifically talking about defendants. Is that an accurate statement of your position on healthcare provider?
Yeah, it is, Your Honor. And that's what it narrows it to, those chapters, and it narrows it to individuals who provided care.
But not as to 102,
But I'm sorry?
but not as to section 102, where it talks about expert qualifications.
It's not defined. The definition doesn't carry over one for one, but I think it's helpful in defining how we should look at healthcare provider in 102, because again, I think we take the same sort of parameters, which is a licensed individual, same specialty, who provides care.
Just to sum up, your argument is that the definition in 202 actually does mean a person licensed who is actually providing healthcare to patients, because the overall statutory scheme assumes that. That's your argument here?
Yes, Your Honor. The chapter is called medical malpractice, so there has to be a practice. There has to be an action. And that's what I'm talking about. It has to be a provision of care. And that's assumed under 766-2024. And that same should be carried over to 766-1025. Thank you for the time. Appreciate it.
Okay, counsel, your time's expired. Thank you. Okay, Mr. Carlisle, you have 440.
Thank you very much, Your Honor.
Mr. Carlisle, could we stop and just hit one thing that we haven't hit on yet that I think you mentioned a lot in your briefs, and you began to mention an argument, which is this concept of access to courts. Can you cite me a case that stands for the proposition that requiring an expert to have an active clinical practice, in order to qualify as an expert, that would constitute a denial of access to the courts? Any case that has actually held that, not just
I don't believe so, Your Honor. Again, the concept, and I understand that we're kind of dealing with two different principles here. One is the supremacy of text, and one is the non-supremacy of text, and saying we should construe statutes in order to gain access to courts, as opposed to using the plain language of the statute.
I'm not sure that they're in conflict, right? They're only in conflict if, your friend on the other side of his construction statute would result in a denial of access to the courts. I'm just asking, what authority can you provide to this court to establish that proposition, that his definition would deny access to the courts?
I'm using the plain language of the text. And again, kind of going back to the argument that we're talking about here, when we're construing these terms, the terms are what they are. We had, my friend on the other side talking about the use of the term profession and extending that to being the practice of medicine under 458, which if the legislature intended that to be the case, they can say medical profession means somebody licensed under 458. They didn't do that. And so that is overreaching. And if we have the same kind of concept that we're trying to say that the legislature is not, again, nitpicking in the sense of like making this extremely difficult to find experts and providing access to courts, then we have to look at it in that way. I think
I mean,
the
brass tacks though, if we disagree with you on your reading of the statute and we hold that Dr. Shore was not a qualified expert, is it your position that your client could not have found somebody else that would qualify under?
I don't think there's
reading
any,
of your friend on the other
Your Honor, no, we're obviously in a situation where summary judgment was entered and the statute of limitations was impacted here. There are people obviously that can render opinions without any doubt whatsoever. We think that Dr. Shore is one of those. However, there were clearly experts that that there would be no doubt about
Let me
their
ask, counsel,
qualifications.
Didn't that in fact happen? Didn't your trial counsel get somebody else who submitted another affidavit from a person who was
I believe,
practicing, except it's past the time frame?
yes, Your Honor.
Okay.
Yeah, again, the facts are what they are, but I think again it was telling again. Number one, practice of medicine under 458 is not used in these terms. Your Honor, Judge Pratt, I think you mentioned and talked about, and we heard about the fact that you can be a professor, you can be a researcher, and still be qualified to render opinions on this. But Dr. Shore, who does consulting and actually physically examines hundreds of patients, somehow he's not qualified. And I would again point out that
let me ask you this, counsel. I mean, under the medical expert definition, talking about profession and how we define the term profession, but it goes on for the person to be a medical expert, they have to meet the requirement of the expert under 766.102. And then that gets back to the active engagement, or consulting with respect to, or the active clinical practice or consulting with. So, I mean, maybe I'm missing something in our good discussion about the term profession, but even if he's in the profession, he's still not an expert unless he comes under the 766.102 requirements. And that leads us to the, what is it, 5A, 2A?
5A2A, I believe. Yeah. Again, Your Honor, it goes. I'm running out of time. It goes back to the same point. I don't see how that can be construed as the active clinical practice of or consulting with. You can be an active clinical practice of the same specialty, or you can be consulting with regard to the same specialty. And I think of when you look at the next two parts of that the court focused on, being a teacher or a researcher, where is the actual, why would it have actual clinical practice being applied to someone who's consulting, but have someone who's never seen a patient in their life, given Judge Pratt's example, perhaps? I see I'm just about out of time. And I would just, again, draw the court's attention, as I did during my previous argument, back to the way, because if I may, diagnosis was discussed, and that was somehow very important to the other side. But if you look at the change to the statute, diagnosis was specifically taken out in 2013.
Counsel,
thank you very much.
If the panel would entertain it, I would like to hear counsel's quick response to the definition of healthcare provider in 102.
Go ahead, Mr. Carlisle.
You'd like to hear mine? Your Honor, I think it was broadly defined. This was not, as I recall, raised or addressed very much in any of the briefs, including the definition in their answer briefs. So,
well, but we have to interpret the whole statute, whether it's raised or not, right? So
correct. No,
Do
correct.
you have a retort to your opposing counsel's position that, hey, look, the definition in 202 assumes that the healthcare provider is actually seeing patients? Do you have a retort to that?
I just don't believe that you can read into that and assume that, and I think it's drafted a little more broadly than that. The same way the other provisions in 102 are very broad in the sense of clinical researchers, etc.
Okay.
Thank you very much. Appreciate your time this morning.
Well argued today. We'll be in recess. Everybody, please stay safe and have a good day.
Thank you, Your Honor.
Thank you very much.